I am Wallace Rudolph from Blackstone Bar Prep, and we are going to discuss a 2013 Florida bar question that was given in July of that year. It is a good example of the type of question that is given where they are testing your ability to know what's necessary in passing a law. The website is www.blackstonebarexam.com. I first want to tell you something about myself. I am a retired law professor, and I've been the dean of 2 law schools and have taught at about 7 law schools. Since my retirement, I have decided to work with students in order to help them pass the bar. The Florida bar is one of the more difficult bars that is given in this country, especially the essays. I have taken the bar in 4 different states, and only in Florida are the essays as complex as they are compared to most other states. In most other states, the multi-state essay exam is usually a 2-issue exam. In the Florida bar, the essay exams are usually 6 to 8 issues in each question. And it is essentially an issue spotting exam, which is graded based on how many issues you actually spot and discuss and analyze. Therefore, it is not too useful to spend too much time on any particular issue. You need to go through them thoroughly and follow the directions. Now let's look at a question itself, and I think it's easier to learn from examples than for me to discuss them in general. Well, this particular question, here it is. Worried about the recent oil disaster, the Florida governor issued a proclamation for a special legislative session, which stated in pertinent part that the legislature is convened for 1 week for the sole and exclusive purpose of considering the legislation to reduce the negative impacts of offshore drilling. Once you've read that, you will have to note that you know you're going to have an issue about the nature of special legislative sessions and the rules regarding such sessions. So a note ought to be put to the side. Then it goes on. On the last day of the special session, under the governor's proclamation, Representative Polk from Polk County drafted and convinced the House to consider a bill to limit medical malpractice litigation in Polk County. And Representative Hardy from Hardy County agreed to vote in favor of the bill in exchange for a provision in increasing the state's tax revenue by requiring a yearly ad valorem tax on motor vehicles registered in Polk County. This tells us, when I read that language, a number of signals should have gone off in your head. First of all, you know neither of those bills had anything to do with offshore drilling. Thus, you need to know, or you must consider, whether there is a rule that requires such legislation to be within the call of a special session. When we discuss this rule, this is going to be an issue that we have to deal with. Secondly, you will note that the first consideration was a tax bill, which raises the question of whether you can have non-uniform taxes based on the rule of tax uniformity under the rules considering legislation. The second issue comes up is that we know we have a 1-subject rule in Florida, and therefore you cannot deal in one part of legislation with 2 different subjects. And the third issue that comes up is whether the state can pass ad valorem taxes. This is an issue, again, that you should have learned from studying Florida con law, that ad valorem taxes are reserved to local government. Ultimately, then, the House properly passed the following bill. Here we have the title, an act relating to medical malpractice lawsuits and ad valorem tax on motor vehicles. Then it says, being enacted by the legislature of the state of Florida. This is another rule that you always have to be looking for. Every bill has to have that language, being enacted by the legislature of the state of Florida. And it does, so that is not a violation. But Section 1, the provisions of this act shall be applicable only to Polk County, Florida. Well, this takes us to a rule about special legislation. If you had a bill that dealt with special legislation, it would have to be either published 30 days before it was entered into the legislature, or be subject to a vote of the people in Polk County. So that's going to be a violation. The second one here is a Section 2. Medical malpractice suits have nothing to do with taxation of motor vehicles. So we have two subjects. Now, in almost every state, and Florida included, there is a one subject rule. It isn't like Congress, which can Christmas tree legislation and put in a number of bills, a number of subjects in one bill and get votes that way. The Constitution has a rule against that. So we have two subjects. We know we have some violations here, and we have an ad valorem tax, and we'll talk more about that later. And we have a problem of special legislation. Immediately after the bill passes, the legislature adjourned for the summer months. The bill was properly presented to the governor as the same day as its passage. Disgusted with the legislature's refusal to address offshore drilling issue, the governor went on a 3-week vacation. The governor never signed the bill, nor did the governor veto the bill. Again, now you have another bell go off. You know there is a rule about vetoes. If the bill is passed during the session, the governor has 7 days to veto. If the bill is passed and they go on vacation, he has 15 days. In this case, we don't have to make a determination because he never signed it, and obviously 15 days went into effect. It would have gone into effect anyway because it's more than 15 days. So the bill is formally adopted. Now, when we get to the call to question, we will discuss this further. And then the last part of the language here is 2 months after the governor's vacation ended, plaintiff suffered a serious injury as a result of a botched operation done by a doctor. Plaintiff sought attorney's representation for medical malpractice action in Polk County. Attorney and plaintiff orally agreed to the attorney's representation for a contingency fee of 50%. Another bell goes off. One, we all know that contingent fees have to be in writing. They have to have certain other elements as to what's in it and right to withdraw. And secondly, contingent fees are restricted to 33% if there is no litigation filed, and 40% if litigation is filed, unless the court approves. So we've got a number of issues that jump out at you. Another issue here, plaintiff does not have $1 million to post with Polk County Clerk of Court. That also raises an issue of access to the court. Prerequisites to filing lawsuits violates separation of powers and denies access to the courts. All right, now what are we supposed to do? We're going to prepare a memo addressing first whether the bill ever became law, then assume the bill did become law, and discuss the constitutionality of the law and its provisions under the Florida Constitution. In your memo, also include a discussion of any unethical consideration for the attorney that arise from plaintiff's efforts to seek representation. We've read it. We've noted a number of issues that are there. Now we have to draft an answer. And the call to question asks you in memo form to determine whether the law was passed. This is sometimes a difficult distinction to consider. Yes, laws may be unconstitutional, but first they have to be passed. All that is required for a law to be passed under the Florida Constitution is that it passes by a majority vote, is signed by the appropriate officers, the clerk in the House and the President of the Senate, and submitted to the governor. If he signs it, it's passed. If he doesn't veto, it becomes law 60 days later. So the law was formally passed in this case. It's only then that we start to consider whether the law is constitutional. So on that first issue, we have to make that distinction. Number two, to assume the law was passed and discuss whether the law is passed is constitutional. That raises all these formal issues that I've mentioned as we've read the question. And the third one is whether the legal representation has ethical problems. We are going to then organize our answer according to the call of the question. I guess I already have told you what we did, and let's look at the answer that I suggest. We deal with them one by one. So number one, the first issue requires you to determine what facts support the passage of the bill as opposed to its constitutionality. Generally, a bill is passed if it's signed by the proper officers, transmitted to the governor, and he either vetoes or allows it to become law without his signatures. The facts indicate the governor did not veto it within the prescribed time, and 60 days has passed since its adoption. So that answers the first issue that was in the call of the question. Now the second issue that came up. The second issue requires you to apply both the formal rules found in the Constitution for the adoption of laws, substantive rules, and protect persons from legislative overreach to the facts of the case. The facts tell you it was passed during a special session. What is the first formal rule? It is that such laws require a 2/3 vote for passage if they are not part of the agenda of the call of the question. In this case, there was no indication that there was a 2/3 vote. The second formal rule is that the bill may only cover one subject, and the facts state the bill covered two subjects. And the third formal rule is taxation must be passed by general laws, and this is a special law. Again, the formal rule states that special laws must give notice or be subject to a referendum, and the facts do not indicate either notice or a referendum. Turning to the substantive rules, the law provides a state ad valorem tax as opposed to a licensing fee, while the Constitution reserves ad valorem taxes to local government. Further, the law places an extra fee on the court's filing, which violates the access to the court rules and interferes with the separation of powers. Clearly, the law has a proper enactment clause, and your client has standing because the law will directly affect her ability to file her medical malpractice lawsuit. The last issue relates to the requirements of the contingent fee agreement that must be in writing and be limited in amount unless approved by the court. The facts state that the agreement was oral, all was an issue, and was more than 33% in settlement or 40% in trial. Therefore, it is invalid and would not be enforceable. You will note how many issues were raised in the case. Each issue must be briefly discussed in order to get the points assigned. Write the law and apply the facts of the case to the law. Now we are ready to write the memorandum. This memorandum is the formal answer that is going to be handed in with your exam. All right, so memorandum. Did an act relating to Polk County medical malpractice lawsuits and ad valorem tax on motor vehicles become law? A bill becomes a law when it is passed by the legislature, signed by the appropriate officers of each house as duly passed, and 2, present it to the governor for signature or veto. And if he signs it, it becomes law. When he does not either sign or veto it within 7 days and the legislature is in session, or if he doesn't sign it or veto it, the bill within 15 days if the legislature is not in session. Lastly, if he vetoes it and it's passed by a 2/3 vote of each legislative body in the present session or in the next session of the legislature, it becomes law. Now, applying the law to the facts of this case, in this case the session had adjourned before the presentment, even though it was on the same day, and the 15-day provision applied. Since the governor did not veto it, it became law 60 days after passage. The fact that the law has multiple constitutional infirmities does not take away the fact that it is a presumptive law until it is declared unconstitutional by proper means. Even a law formally adopted may be unconstitutional because of the following 8 reasons. 1, it was passed in a special session and the subject of the bill was not included in the call of the session unless the legislature extended the agenda for a special session by a 2/3 vote. 2, the law was unconstitutional because it violated the single subject rule and because it included 2 subjects, malpractice and ad valorem taxes. 3, the law is unconstitutional because it violated the rule that a single subject must be expressed in the title and expressed 2 subjects in the title. 4, the law was a special law because it has limited its application to a particular county and it failed to make provisions for either notice or referendum in that county. 5, the law was unconstitutional because it provided for an ad valorem taxes payable to the state on personal property. The state may not impose ad valorem taxes but may only provide for licensing fees. 6, the law is unconstitutional because it creates a tax by special law. Taxation must always be by general law and be uniform throughout the state. If this is too much information at one time, you are able to pause the video and go back and look at the prior information again and work at your own pace. 7, the law is unconstitutional because it denies access to the courts by requiring a bond to access a court. And 8, the law is unconstitutional because it violates the separation of powers by controlling court procedure rules. In this case, the contingent fee agreement with the attorney is unethical because it is not in writing, does not include the required provisions about clients' rights and termination, and exceeds the amount of fees that can be charged without court approval. Generally, in a contingent fee agreement, the fee is limited to 33% before filing an action and 40% after filing, with further limits when the recovery exceeds certain amounts. This essay had a lot of issues, but in grading this kind of essay, each of those issues counted for a certain number of points. And it's very important when you're writing this to make sure that you do not leave points on the table or skip over issues that are there. And the more points that you get, the better. This is the best way to attack a con law exam. And this isn't the only one. There are a number of other con law essays that have raised similar issues on the application of the rules about passing laws. If you enjoyed this, come to our website and we will go over every question on that website that has been posed in the last 12 years on the Florida bar exam. Again, our website is www.blackstonebarexam.com.